So imagine submitting a video,
Mhm.
right? Like a video that just clearly proves your truck is legally sound.
Right, actual hard evidence.
Exactly. And you back it up with a sworn statement from a certified mechanic. You submit all of this just to clear a citation you got for a broken ABS light.
Hmm.
And then not only does the officer who wrote your ticket deny your appeal, but the agency actually threatens you with a $10,000 fine for submitting, quote, false documentation.
Which is just, it's wild.
It's a nightmare scenario.
Yep.
But, up until 2026, that wasn't some isolated incident. That was basically standard operating procedure for challenging safety records in the trucking industry.
Yeah, unfortunately.
So welcome to this deep dive. Today, our mission is to unpack a stack of excerpts from the guide, Navigating FMCSA Dispute Resolution and the DataQ's 2026 overhaul. We're really trying to decode how the industry's main mechanism for fighting unfair safety records just underwent, frankly, a massive transformation.
Yeah, and the absurdity of that ABS light story you just mentioned, it perfectly captures why this overhaul was just inevitable.
Right.
For years, the data queue system, which for those who don't know is the portal where carriers and drivers challenge their federal and state safety data, it operated as this closed loop. The structural flaw was just glaring.
Okay, let's unpack this for a second,
Yeah.
because the source material includes this incredibly striking quote from transportation risk expert Rob Carpenter, and it really lays out the stakes here.
Oh yeah, that quote is spot on.
He says, before a shipper loads your truck, before an underwriter decides whether to renew your policy, they pull your FMCSA safety data.
Exactly.
So whether you're an owner-operator or you're managing some massive national fleet, this isn't just bureaucratic record-keeping. It is literally the gateway to your livelihood.
Right. We are talking about a digital profile that basically dictates your commercial reality. It dictates whether you get lucrative freight contracts, what your insurance premiums are going to be, and even, your physical experience on the road.
How so? Like with the physical experience part.
Yeah. Well, specifically, how often your trucks are pulled over for roadside inspections. Bad data means you get flagged more often.
Wow. Okay. I was reading through these sources, and the best way I can conceptualize this for you, the listener, is that your DataQ's profile is essentially like a credit score for truckers.
That's a really good way to look at it.
Right. Because if there's a mistake on your credit report, your quote-unquote interest rates, which in this case are your insurance premiums, and the frequency of those roadside inspections we just mentioned, they just skyrocket.
Mm-hmm.
And your loans, like the premium freight contracts you need to actually survive, those get flat out denied.
Yeah, and that analogy holds up especially well when you look at the burden of proof. Just like a credit score, you are essentially assumed guilty by the algorithm until you prove your innocence.
Oh, wow. Yeah.
The negative data just sits there, actively damaging your business metrics until you proactively initiate the dispute process.
But, okay, if this safety data is the financial lifeblood of a trucking business, the mechanics of how it gets disputed are critical. And I'm really struggling with the logistics of the pre-2026 system.
It was messy, to say the least.
Right, so you have an officer on the side of the highway who enters a violation into the federal database. When the carrier files a DataQ's challenge with that video evidence, did the system, did it literally ping that specific officer's terminal and ask them to grade their own paperwork?
In a lot of jurisdictions, yes, that is exactly how the routing worked.
It's insane.
The challenges were sent right back to the issuing agency and very often directly to the desk of the actual officer who wrote the citation in the first place.
Wait, really? Let a student grade their own final exam?
Yeah.
How did that ever pass for due process?
Right, and this raises an important question about human psychology and, structural bias. An officer's rarely going to look at an appeal and readily admit, oh yeah, I made a fundamental data entry error, or I made a bad judgment call on the side of the highway.
It creates a literal kangaroo court. You are asking the prosecution to act as the appellate judge.
Exactly. Which naturally led to what the industry called rubber stamp denials. And the data from 2024, right before the new rules kicked in, really highlights the sheer scale of the friction here.
What were the numbers looking like?
Well, the DataQ system processed 71,862 total requests that year alone.
Over 70,000 challenges in a single year. That's huge. And the breakdown of those numbers is really fascinating, too. Over 63,000 of those requests were fighting inspections and violations, compared to just over 8,000 challenging crash data.
Yeah, it was heavily skewed.
So the day-to-day friction at the roadside inspection level was generating this massive tidal wave of disputed data.
And the success rates for those violation challenges were just abysmal. Compliance consultant Brandon Wiseman noted that violation challenges were the least successful category by far.
Great.
They averaged only a 39% success rate. So the agency was essentially siding with itself more than 60% of the time, almost regardless of the evidence presented.
So we have 50 different states with 50 different standards operating this fundamentally biased review loop. How does the federal government physically force state-level agencies to, give up their localized power and actually play fair?
Well, the 2026 final rule didn't just ask nicely. It hit them right in the wallet.
Okay, my favorite kind of leverage.
Yeah, the April 16, 2026 final rule is really a masterclass in administrative leverage.
Right.
The FMCSA tied state compliance directly to Motor Carrier Safety Assistance Program grant funding. That's the MCSAP.
MCSAP, right. It reminds me of like a corporate parent company freezing the operating budget of a rogue subsidiary until they pass an external audit.
That's pretty much it.
But does threatening federal grant money really force a massive state agency to completely overhaul its internal review process?
It absolutely does, because MCSAP funding isn't just, a nice little bonus. For many states, it is the foundational capital for their commercial vehicle enforcement programs.
I see.
It pays for the inspectors, it pays for the weigh station technology, the training. If a state fails to follow the newly mandated rules for independent review, they risk losing that entire federal pipeline.
So the financial incentive for immediate reform was overwhelming.
Exactly.
So let's look at the actual mechanics of what these states are now forced to do to keep that money. They have to implement this mandatory three-stage independent review structure.
Right, the 3 stages.
So stage 1 is the initial review, and that's capped at a maximum of 21 days. And from the source material, the crucial mechanical shift here is that if a correction is being denied, that decision cannot be made solely by the officer who issued the violation.
Yeah, it introduces a second set of eyes immediately. If the state wants to uphold the citation, an administrative reviewer has to sign off on the officer's logic.
Okay, and if they still deny it, you move to stage 2, which is reconsideration.
Yeah.
The state has another 21 days here, and this stage must be handled by an independent subject matter expert who had absolutely zero involvement in the initial decision or the roadside stop.
Completely independent, yes.
Right. And finally, you have stage 3, the final review. This takes up to 45 days and escalates the challenge to a senior leader or a completely independent panel. But I have to push back on that timeline, though.
Okay, what's your concern?
Well, why 45 days for that final stage? I mean, if your insurance renewal is pending and your rates are based on a false violation, 45 days seems like a really long time to wait. That could be enough time to bankrupt a small fleet.
Yeah, the timeline is undeniably a friction point for carriers. Originally, the proposed rule actually demanded a 30-day deadline for that final stage.
So why did it get extended?
Well, during the public comment period, enforcement agencies detailed the sort of logistical nightmare of physically convening an entirely independent panel of senior leaders.
Scheduling.
Exactly. Aligning the schedules of top brass who are completely disconnected from the original citation. It simply takes time. So the 45-day window is essentially the administrative price of genuine transparency.
And that transparency is highly structured now, right? They can't just stamp denied on your file anymore and walk away.
Not at all. Under the 2026 rules, a denial requires the actual name and title of the decision maker.
Nice.
It mandates a complete, itemized list of all the evidence they reviewed. And, crucially, it requires specific legal or factual reasoning explaining exactly why the carrier's evidence wasn't sufficient to overturn the violation.
That itemized reasoning is a massive tool for accountability.
It really is.
And there is another critical mechanism built into this overhaul regarding historical data. The FMCSA actually expanded the look-back windows.
Yes, this is a big one.
You can now challenge inspection data for up to 3 years from the date of the inspection. And for crash data, you can go back 5 years.
Right.
So if you have an old blemish that's just been dragging down your safety percentiles, you now have the runway to actively clean it up under these fairer rules.
Exactly. But now that the structural playing field has been leveled, we have to talk about how carriers actually utilize this tool. Because, just having an independent review doesn't automatically equate to a victory. The burden of proof remains squarely on the requester.
Right, you still have to prove it. And here's where it gets really interesting. When you look at the strategic playbook for data queues, your success rate is dictated almost entirely by the classification of what you are actually challenging.
Yeah. What are the targets?
The source material outlines the high success targets. So duplicate records, where the same inspection is basically entered twice, those have a 75 to 90% success rate. Data entry errors sit between 70 and 85%.
Mm-hmm.
And wrong carrier assignments, where a violation is pinned to your DOT number, but it was a completely different company's truck. Those succeed 60 to 80% of the time.
And the underlying logic here is pretty straightforward. These are administrative facts. They aren't subjective field observations.
Yeah, it operates just like disputing a charge on your credit card. Like if you call the bank to prove a charge wasn't yours, or that the cashier swiped your card twice, the bank just looks at the digital timestamps and clears it easily.
Well, super simple.
That's a data entry error or a duplicate. But if you call the bank to argue that the television you bought wasn't actually worth the price the store charged you, the bank isn't going to side with you. Arguing an officer's judgment call is incredibly difficult, but arguing a clerical error is highly successful.
That's a perfect analogy. And that same logic extends to the crash side of the data, too, through the Crash Preventability Determination Program, or CPDP.
Right.
This program is integrated directly into data queues, and it outlines 21 specific crash types that the FMCSA officially deems, quote, not preventable.
But wait, if I'm driving down the highway and I get rear-ended, or like I hit an animal that suddenly jumps into the road, why is that even on my safety record to begin with? I'm obviously the victim in that scenario.
It's a fair question. It's because the initial data collection at the state level is purely factual and objective. It just notes a commercial motor vehicle was involved in a tow-away crash, an injury, or a fatality.
Okay, so just raw data.
Right. The database doesn't automatically assign fault. It requires the carrier to initiate the CPDP process to officially reclassify that crash. So the 21 categories cover scenarios where the commercial driver genuinely had no evasive options.
So things like infrastructure failures, a bridge collapse, or a wrong-way driver hitting you head-on.
Precisely. And the mechanism for proving these scenarios has completely shifted, mainly with the ubiquity of dash cams.
Oh, dash cams are a game changer.
Yeah. Video evidence is undeniably the most powerful tool in the CPDP arsenal right now. If you submit a police report alongside dash cam footage proving your driver was legally stopped at a red light when a passenger vehicle T-boned them, that is a highly successful mechanical path to getting that crash removed from your crash indicator basic score.
Right. And speaking of highly successful paths, the experts consider one specific type of challenge to be the absolute golden ticket in data queues. It's called an adjudicated citation.
The golden ticket, exactly.
Let's say your driver gets a ticket during an inspection. You hire local counsel, you take it to a municipal court, and the judge either throws the ticket out or the driver is convicted of a lesser charge.
Right, you win in court.
Yeah. You then take those local court documents and file a data queues challenge, making sure to include the original inspection report, the citation number, and the court resolution.
And this consistently has higher success rates than any other complex challenge because the FMCSA isn't relitigating the facts. They are simply aligning their federal database with the local court's ruling.
Makes total sense.
But, we also really need to address the friction points that actively harm carriers in this system. The source material is adamant about what not to do.
Okay, what's the biggest mistake?
Do not use data queues to complain about an officer's attitude. It is a data quality portal. It is not a customer service complaint line.
Oh, man, yeah. Submitting a challenge that says the officer was rude and targeted my driver without any supporting mechanic statements or photos is just a massive waste of bandwidth.
Completely. A reviewing agency is never going to invalidate a sworn officer's official report based purely on a carrier's undocumented, emotional narrative.
Right.
Filing those frivolous challenges alienates the reviewing agencies, and it just clogs up the mandatory 21-day review queues for carriers who actually have legitimate documented data errors.
Yeah, don't be that guy. So we have the mechanisms to fix the data, but we really have to look at the escalating consequences of ignoring it. If a carrier decides that gathering evidence and filing data queues challenges is just too much administrative work, the fallout escalates rapidly.
Oh, it goes from a bureaucratic headache to an existential business threat real quick.
Right.
The enforcement escalation is highly structured. It usually starts with a trigger, say, a severe roadside inspection violation or maybe a carrier CSA percentiles, cross a critical intervention threshold because they just didn't clear out old, inaccurate crash data.
Okay, so then what?
The agency might start with a simple warning letter. But if the data doesn't improve, they escalate to a comprehensive on-site compliance review. They'll start auditing hours of service logs, maintenance records, and driver qualification files.
And if they find systemic issues during that review, they issue a notice of claim, or NOC. And the 2026 inflation-adjusted fines attached to these notices are severe.
Very severe.
Like for general safety violations, hours of service falsifications, or ELD issues, the maximum penalty sits at over $16,800 per violation.
Per violation.
Operating after an out-of-service order jumps to over $27,800 and actually includes a criminal referral
Right.
and hazmat violations. A staggering $89,678 per violation.
Yeah, the hazmat penalties are so severe because the potential for catastrophic public harm is exponentially higher, so the federal statute authorizes these massive punitive multipliers.
I mean, I've seen smaller carriers look at fines that high and think their only option is to just ignore the notice of claim, fly under the radar, and hope the agency gets distracted. Is there ever a strategic advantage to delaying a response?
No, it is the absolute worst move a carrier can make.
Really? Just the worst.
The mechanism of a notice of claim is essentially a countdown timer. If you fail to formally respond within the strict time frame, which is usually 30 to 45 days, it triggers an automatic default judgment.
Ouch.
Yeah, the agency no longer has to prove the violations. The full proposed penalty is assessed against your company without any avenue for negotiation.
You essentially forfeit your right to due process by simply letting the clock run out.
Exactly. Conversely, though, engaging with the system offers mechanical pathways to survival. If the violations cited in the NOC are legitimate, you immediately correct them, thoroughly document the new safety protocols, and enter into an informal settlement process.
Okay, so showing you're fixing it helps.
Huge help. By demonstrating good faith corrective actions, the FMCSA will frequently reduce those massive fines by 25 to 50% just to keep the carrier operational while ensuring compliance.
But the regulatory fines aren't even the apex of the thread here. The source material brings in the chilling perspective of litigation defense attorney Douglas B. Marcello. He outlines how uncorrected data queues records literally fuel quote-unquote nuclear verdicts in civil court.
Yes, because when a commercial vehicle is involved in a major accident, plaintiffs' attorneys employ a strategy known as the reptile theory.
The reptile theory.
Yeah, they aren't just arguing about the physics of the crash in front of them.
They're actively trying to bypass the logical centers of the jurors' brains and trigger primitive fear-based responses, like a reptile brain.
Exactly. They paint a picture of systemic negligence. The attorney will stand in front of the jury and say, "Ladies and gentlemen, this company didn't even care enough to fix a documented brake violation from 3 years ago, so why would they care about your family's safety on the highway today?"
Oh, wow. That's powerful.
And the raw material they use to build that specific narrative is an uncorrected CSA record. Every bad piece of data entry, every duplicate violation, every unpreventable crash that the carrier just didn't bother to fight in data queues, it all becomes admissible ammunition.
So by aggressively using the new 2026 data queues review stages to scrub inaccurate data, you are actively stripping away the ammunition plaintiff attorneys use to secure these multi-million-dollar judgments.
You are building a bulletproof litigation defense record in real time.
That's incredible. There is one final mechanical nuance we must clarify, though, for listeners operating cross-border logistics.
Right, very important.
While we've seen significant harmonization between the U.S. and Canada regarding ELD mandates and cargo securement, the data queue system is strictly a U.S. jurisdictional mechanism.
Yes.
If you are an Ontario-based carrier running freight into Michigan, you must use data queues to clear your U.S. operations data. But data queues does not care about your provincial safety rating in Canada.
No, Canada handles its own internal commercial disputes through the Federal Mediation and Conciliation Service under the Canada Labour Code. The datasets and the appeal mechanisms do not cross the border, even if the trucks do, right? The jurisdiction lines are absolute. You have to master the data queues playbook specifically to protect your operating authorities south of the border.
Synthesizing everything we've unpacked today, the core operational truth is undeniable. Managing your data queues profile is no longer an optional, rainy day administrative chore.
No, it's really not.
It is a critical daily business practice. The 2026 overhaul finally provides actual structural due process. You have independent reviewers who didn't write the ticket. You have hard administrative timelines, and you have mandatory transparency. As FMCSA Administrator Derek Barr stated upon rolling out these rules, America's hardworking truck drivers deserve a system that treats them fairly.
And, if we connect this to the bigger picture here, we are moving rapidly toward an industry where algorithms, risk models, and automated data literally dictate who gets to haul freight and who gets insured to do it.
Absolutely.
Our digital reputations often precede us long before we ever shake a client's hand or speak to an underwriter. The 2026 overhaul undoubtedly leveled the playing field by removing that kangaroo court loop, but it also permanently solidified the fact that the burden of proof rests entirely on you, the driver and the carrier, to essentially police the government's data.
That's a huge burden.
It is. It makes you wonder, is this system where you must constantly defend your digital footprint from bureaucratic errors just to stay in business, is this the final evolution of how we manage transportation safety? Or is it simply the beginning of a much larger fight over who truly owns, controls, and profits from our professional data?
Man, that is a thought that will definitely stay with you the next time you log into a federal portal to upload a dashcam video. Thank you for joining us on this deep dive. Our advice to you: don't wait for a catastrophic compliance review or a nuclear verdict. Pull your own safety profile and start auditing your data today. Your credit score for the road depends on it.